If you've been injured in a car accident in Iowa, you've just become the target of a multi-billion-dollar industry designed to get you to accept less money than you deserve. Insurance adjusters use 6 specific tactics to slash your settlement by thousands of dollars. But in this video, I'm going to turn their own playbook against them and give you 6 proven strategies to protect yourself from insurance industry dirty tricks. Hi, I'm Tim Semmelroth of RSH Legal. For the past 27 years, my firm and I have been helping Iowans fight for the compensation they deserve. If you or someone you know has been injured and wants a free consultation with an attorney they can trust to fight for their case, give me a call at 319-895-1847. Strategy 1. Never give a recorded statement without protection. Here's something that may shock you. That friendly insurance adjuster who calls asking for just a quick statement has actually been trained to use your own words as weapons against you. After 27 years of helping Iowa car accident victims, I've seen this tactic destroy thousands of dollars in rightful compensation. You might think that giving a recorded statement shows that you have nothing to hide, but the reality? These recordings are analyzed word by word for inconsistencies that can be used against you. Even slight variations as to how you describe the accident, days apart. Insurance representatives are coached to sound caring and sympathetic to gain your trust. But don't be fooled. Here's what they don't want you to know. You are under absolutely no legal obligation to give them a recorded statement. Refusing will not reduce your compensation 1 penny. In fact, it protects your claim from being undermined before it ever really even begins. When the adjuster calls, here's exactly what to say. I'll be happy to speak to you after I've healed and have a clear picture of my injuries. Please contact me only in writing. And then hang up. At our firm, we only allow our clients to speak to adjusters when one of our attorneys is present to protect them. Strategy 2. Don't sign medical releases that expose your entire health history. What if I told you that signing the wrong piece of paper could give insurance companies access to decades of your private medical records, including treatments that have nothing to do with your accident? This is exactly what happens when you sign their standard medical release forms. Insurance companies are entitled to review the records of medical treatment related to your car accident. But here's the alarming truth. Most insurance industry medical release forms are deliberately written to give them access to all of your medical records, including pre-accident health history that has no connection to your injuries. Why do they want this irrelevant information? Because they'll use your past medical history as justification for making unreasonably low settlement offers. Had back pain 8 years ago? They'll claim your current back injury isn't from the accident. Had previous headaches 10 years ago? They'll argue your concussion symptoms are pre-existing. Here's how we protect our clients from this unfair tactic. First, we advise them never to give the other driver's insurance a medical release until we've reviewed their medical records first. If we uncover items in your medical history that may impact your claim, we make sure that you know about it before the other driver's insurance company does. When we do provide a signed medical release, we make sure it only applies to relevant medical treatment, not your entire health history. Strategy 3. Don't let insurance companies control your timeline. Have you ever noticed how insurance adjusters suddenly become urgent when they want something from you? They'll say things like, "We need this right now," or "You won't get fair compensation if you don't act immediately." This is manufactured urgency designed to pressure you into making mistakes. Here's what they're hoping you don't know. Iowa car accident victims generally have 2 full years from the date of the accident to either settle their claim or file a lawsuit. 2 years. While there are some limited situations where you need to act within 6 months, you only have to act when the law requires it, not when some insurance representative demands it. So why did they create this false urgency? Because time is your ally, not theirs. The longer you wait, the clearer your injuries become, the more medical evidence you can gather, and the stronger your case gets. They want you to settle before you understand the full extent of your damages. When an adjuster tries to rush you, remember this: legitimate settlement offers don't come with artificial deadlines. Take the time you need to understand your injuries, get proper medical treatment, and make an informed decision about your future. Strategy 4. Don't let them dictate your medical treatment. Here's one of the most unethical tactics I see: insurance adjusters threatening that they won't pay for certain types of medical treatment. They'll say things like, "We don't cover chiropractic care," or "That specialist is too expensive." This is completely false and they know it. Under Iowa law, the at-fault driver's insurance is responsible for paying all reasonable and necessary medical treatment caused by the crash. What qualifies as reasonable and necessary is decided by your doctors and medical providers, not by some insurance representative sitting in a cubicle hundreds of miles away. Now, what makes this tactic particularly unethical is that most insurance representatives know the truth and are still using this "we won't pay" line to bully accident victims into stopping legitimate treatment. They're gambling that you'll believe them and stop getting the care you need. But here's what you need to understand: you should get whatever medical treatment a doctor recommends until either you're healed or until a medical professional tells you that the injury is as good as it's going to get. Stopping medical treatment before this point could devastate your ability to get fair compensation. In the short term, you should be submitting your medical bills to your own health insurance, auto insurance if you have medical payment coverage, or your employer's workers' compensation insurance if the accident happened while you were on the job. Don't let insurance adjusters practice medicine without a license. Strategy number 5. Never accept the first settlement offer. What if I told you that most insurance companies design their first settlement offer to be so low that even they expect you to reject it? Yet thousands of accident victims accept these lowball offers every year, not understanding that this one decision will cost them potentially thousands of dollars. Here's the crucial fact that they don't mention. Most insurance companies will issue only one settlement check for your car accident claim. After that one check, they will never pay additional money for that claim in the future, even if your injury gets worse or you need future medical treatment. You should avoid quick settlements if you're still receiving medical care, if your injuries will likely require future treatment, or if you haven't been able to return to normal activities, especially work activities. But there's a hidden trap in settlement offers that catches some people completely off guard. Before reaching a settlement, you may have medical bills or lost wages that have already been paid by your health insurance, auto insurance, short-term disability, or workers' compensation. Almost all of these policies require you to pay back any amounts they covered if you reach a settlement with the at-fault driver. This legal obligation is called subrogation, and it can leave you with little or nothing after a settlement. I've seen accident victims think they're getting a $50,000 settlement only to discover that they owe $40,000 in subrogation, leaving them with just $10,000 for their pain, suffering, and future medical needs. We protect our client from this shock by calculating exactly how much of any settlement offer they'll actually keep, and we work to reduce any subrogation obligations whenever possible. Strategy 6. Don't assume that your own insurance company is your friend. There's a reason why insurance companies spend millions on advertising claiming that they're on your side, because they're not. In fact, the biggest threat to getting fair compensation after a car accident may come from your own insurance company. This happens when the at-fault driver has no insurance or doesn't have enough insurance to cover your damages. Right now in Iowa, drivers are only required to carry $20,000 in liability insurance. What happens if your medical bills alone are $50,000? Your only chance for fair compensation comes from your own uninsured or underinsured motorist coverage. But here's what's truly alarming. Even the possibility that you may make a claim under your own policy causes your insurance company to go into pay as little as possible mode. Your own insurance representatives are trained to use the same tactics to reduce claim payouts, even when you're their own customer who has been paying them premiums for years. They'll pressure you for recorded statements, demand broad medical releases, and make lowball settlement offers, just like the other driver's insurance would. That's why you can't assume that your own insurance company is looking out for your best interest. They're a business focused on profits, not a friend who's looking out for your well-being. Here's a bonus strategy: why the insurance companies fear attorneys. Insurance representatives will often tell you that you don't need an attorney because we can just work this out on our own. But here's what they're not telling you. There is no we in this situation. That adjuster is not your friend and is not motivated to ensure you receive fair compensation. Their job is to settle your claim as quickly and as cheaply as possible. Nothing more. Want proof? Internal insurance industry documents have revealed that companies train employees to discourage accident victims from hiring attorneys. They even give bonuses and raises to employees who can consistently talk people out of consulting with lawyers. Now, why are these companies so desperate to keep you from talking to an attorney? Because insurance industry statistics show that represented claims settle for 2 to 3 times more than unrepresented claims. That's not my opinion. That's from Allstate's own training manual. Courts and regulators in New York, Pennsylvania, and Washington state have actually ordered insurance companies to stop discouraging accident victims from consulting with attorneys. Unfortunately, at this time, Iowa does not offer this protection. The initial consultation with a car accident attorney is typically free, so you can learn your rights and whether an attorney can help you without spending any money. There is no good reason not to talk to an attorney before signing insurance company paperwork or settling a claim. Remember, insurance adjusters are trained professionals whose job is to pay you as little as possible. Don't go into this fight without someone in your corner who knows their tactics and can protect your rights. Handling an insurance company alone can be risky. One wrong move can cost you the settlement you deserve. Now, these strategies are a starting point, but having the right attorney makes all the difference. If you or your loved one have been injured here in Iowa and you would like to set up a free consultation with an experienced attorney who will fight for what you deserve, please give us a call today at 319-895-1847. Our conversation is confidential, costs you nothing, and can potentially get you the best possible settlement for your case. Now, if you found this video helpful, subscribe to this channel and make sure you watch this next video.